So my name's Eliza. I'm calling from the Administrative Appeals Tribunal. Can I please just check I'm speaking to Dr. Rich Mclean?
Yes.
Thank you. So I'm calling in relation to a video hearing in the matter of Mclean and Comcare. In a video directions hearing, apologies. In the call already, Senior Member Fernell.
Can I write this down? I've just got up. I didn't even know this was on today. Hang on. Who? Fernell?
Yeah, Senior Member Fernell, the tribunal member, and Ms. Watson, the representative for the respondent for Comcare. So the next voice you'll hear is Senior Member Fernell, and this video directions hearing is being recorded. And just so you know, we ask that no one else record tribunal directions hearings without the permission of the member.
Okay. Good morning again, Ms. Watson. Good morning to you. Is it Mr. McLean or Dr. McLean?
It's Dr. McLean, and I just wondered if I may be permissed, Your Honour or Senior Fernell, to make a statement before we start.
Look, I'm sure Ms. Watson has limited time available. I do too, so please feel free, but if you could make it short, please.
Okay. I have been the victim of systemic abuse, which led to my suicide in a hospital. Since that time, I have been oppressed by the government. I have also suffered an acquired brain injury. The government, having already oppressed me so much that it ended in my suicide, which was deemed fatal, and then it was covered up, and I've lived in abject poverty ever since, is unconscionable. And I have also, I'll be very quick, I've also been let down with lots of money by the Australian Human Rights Commission and Comcare and AAT. Now, I've written to Michaelia Cash, the Attorney General, and I pointed out that in this meeting that we're having today, it's unfair, inequitable, and it's probably against legal principles to get a disabled person who doesn't even know why they're being denied under a section of the Act, or the SRC Act, and the government who has already oppressed me, and that Attorney General Cash didn't intervene in my justice issues and the clear corruption that happened. I believe that this is inequitable, unfair, and I'm unprepared, and I don't have capacity to understand what's going on, you see. So I'm saying now, sternly, that the government, having already killed me, then covered it up, and having the Attorney General condone me having no medication, no home, I'm squatting, and no care, is unconscionable. And further to that, I believe that whatever happens today, it's going in one direction, and that's victory for the government. And due to those things of me being taken advantage of, it being an illegal, unequitable fight, and totally unbalanced and more than likely corrupt, that I will fail, I don't agree or permit this to go ahead unless I have a lawyer or advocate.
Thank you, Dr. McLean. Look, I hear what you said. I suppose, can I just tell you what the purpose of today was? It was just to work out, you've made an application to the tribunal for review of a decision, as you know. And the question is, what happens to that application if you don't want it to go ahead? I'm not. You see what I'm saying? You've made the application, and the question is, how do we proceed with that application if you don't want it to proceed?
Yes, I know what you're saying, but by the other token, if it proceeds, it's only going to go one way, me losing. So I think it's fair that I have an advocate or representative, or at least a very basic statement of how and why it's rejected under the SRC Act. I've never heard it. I don't understand it.
Okay. Look, in terms of it proceeding without an advocate, obviously unrepresented applicants suffer a disadvantage, but the issue becomes whether that means an application sort of staying suspended animation for however long it takes for a person to not get representation. So, from a tribunal's perspective, a matter just can't be in permanent abeyance pending a party, whichever party, getting or not getting representation. Otherwise, as I say, there will be a host of matters in suspended status for an indefinite period. So, just from the tribunal's own resources, that can't be allowed to happen. We can't.
Well, what also can't be allowed to happen is that the government, or having already killed me and then covered it up, and I have a brain injury, which goes against the human rights abuses to take advantage of a person in a legal way, which is already unfair and I will lose. That can't be allowed to happen either. It goes against human rights abuses and disability law. It's against equal opportunity and it's discrimination. And not only is that, but it is unequitable and probably illegal fight to have this corruption that I've clearly captured in my website, my whistleblower website, of the Attorney General condoning this meeting going ahead, considering I've already been taken advantage of by other statutory authorities under her portfolio.
Well, can I ask you, Dr. McLean, how do you propose that this matter go ahead or not go ahead? I'm just trying to work out what your solution to this conundrum is.
Well, it's my understanding that a delay, defer and deny tactic has happened for a long time. Now, I'm very well aware, please indulge me just for a minute, I've been delayed, denied, deferred from Comcare as, you know, a section of the Act and denied my work cover. I live in poverty, abject poverty. I haven't got my medication, I haven't got food, and I've just been evicted. I'm a human rights awarded author and a celebrated national figure, having spoken in Parliament and all over the news media from Dubbo to Montreal. I have been character assassinated, and this is very clear and evident on my website. Now, I don't know how much it's worth, but I think the work cover is something like 95% of your wage for 45 weeks and then onwards. I now, because of my hospitalisation, which HCF and work cover contributed to, was hospitalised for a logical reason that I was paranoid, but this was more oppression from the government. It was decided after that suicide attempt, which was fatal, that, well, now I have an acquired brain injury. So I don't know what's happening with work cover if it goes ahead, if it's going to be a TPD payment, or if it's going to be a lump sum, or if it's just going to keep going, or what the situation is in regards to that, you know? Do you know what I mean?
Look, Dr. McLean, I appreciate that you're in seek to downplay them by characterising them in those terms. But the point, I suppose the point of today is to work out, you've made an application, how do we progress that application? I've asked you how you propose we progress the application. And
well, this is the thing. I have an acquired brain injury. I don't understand and I can't concentrate and I can't remember what I was saying. This is why I'm being taken advantage of. Now, what I would...
No, I'm not seeking Dr. McLean, please. I'm not seeking to anyone, the tribunal, take advantage of you. What I am trying to understand is how we progress the matter. And
Well,
I think your issue is, well, we can't progress the matter until you're legally represented.
no,
But that can't, from the tribunal's perspective. Are you still there, Mr. McLean? Dr. McLean?
yes, I'm still here. Yes?
Oh, right. Okay, sorry. So from the tribunal's perspective, the matter just can't stay in a state of a suspended animation. It's either progressed or withdrawn. It can't just stay neutral.
So you're forcing me to go through with this, even though I have a brain injury.
I'm not for no. You
I don't want it to not progress, because that'll be the end of it, and I'll lose probably $1 million. Does that make sense?
well, if you don't want it not to progress, then I'm asking you, how do you think we should progress it?
Well, I'm not a legal person. I'm just a dude, okay? Now, I need to understand what, in simple language, is the reason why my work cover's been rejected.
Look, I haven't read your file in detail because it hasn't come to a hearing at this stage, but my preliminary understanding of the respondent's response is that you're not an employee of the agency. That's correct.
Well, that's just you saying it's correct, but I say it's not correct. I mean, I can Google...
Well, see, I suppose that we can...
would you like to see my government identification? Would you like to see that?
Dr. McLean, I have seen that you have been registered to provide services under the NDIS scheme.
No, have you seen my... you're not listening to me, please listen to me. Have you seen my government ID as a health provider?
No.
Well, I'll bring it up right now. What's your email? I'll email it to you.
That would be terrific.
Pardon?
I'm sorry, Dr. McLean.
I can email it to you right now, if I can find it.
Dr. McLean, this is not... Dr. McLean, this is not... I'm not seeking to have the hearing of your application now. What I am seeking to work out is how we progress the matter.
Yeah, but I know, sir. But you're saying...
I understand your... Sorry, No, please, if I can just finish this. My understanding of your issue was that you weren't aware why your claim was rejected. Now, my understanding is that your claim was rejected because the respondent's contention is that you're not an employee. Now, you believe you've got an answer to that. Then the matter can progress and we can hear that answer and we can hear the response. So you do know, as I understand it, why the respondent is rejecting your claim. If you believe you can make out you're an employee, then we should progress to a hearing.
I can prove that I have a government login through Proda where I have an ID and I also have a government... like I've gone over this in the past. This is really difficult for me as a person with no food, okay? It's really unfair that I'm forced into this. I've just got up. I didn't even know this was on today because I've forgotten. Look, I can prove beyond reasonable doubt that with my government identification that I am an employee of the government because I have a profile on the government's website. Would you like to see that, sir?
Dr. McLean, can I respond to that proposition? If you can prove it, then we should go to a hearing and you get your opportunity to prove it.
Well, I can prove it now. I don't need to prove it later. I've already proved it because I've already given it to you.
No, sorry, Dr. McLean, somebody lodging material with the tribunal doesn't mean the tribunal should thereby automatically be satisfied of the validity of the proposition which is made by reference to that material. You can understand that. we need to go to a hearing so we can hear the respondent's response to your contention that you're thereby an employee.
So can I ask very basically, how much is this worth?
I don't know.
Can you ask the other lady, please? How much is this worth if I win?
I'm not in a position to answer that question, Senior Member.
Okay, thanks.
So we don't even know what we're arguing for, is that correct? We don't have a dollar amount on what we're arguing for.
The tribunal's not arguing anything, but Dr. McLean, you've made an application. Presumably you've got familiarity with why you've made the application and the materiality from your perspective of that application.
Han, can you just wait 2 seconds? Wait on. Sorry, I'll be 2 seconds. Wait on.
No worries.
Excuse me, just for 1 second, all right? Oh, I haven't got. I didn't know I was going to be called, so I haven't got internet connection at the moment. Wait, I'll just see if I can log on. Sorry for the confusion. I get confused in the head. You'll have to bear with me, please. Now, under which section of the SRC Act are you saying I'm not an employee, please? Can you please comment on that?
Look, Dr. McLean, this is not the hearing, but my can I make a general comment? I won't ask Ms. Watson to respond to that because you'll probably see there's section 14 of the Act, which says that a liability compensator arises in relation to an injury suffered by an employee. So that's where the necessity for a person to be an employee arises from.
Hang on. Can you just send me? Can I see that act? Can I see that? I'll just Google it. Wait, I think I looked it up.
I don't know what's before. I don't know what's before you.
Senior Member, I'm very sorry, but I probably note at this point I have another directions hearing at 10 o'clock.
Yeah, look. Okay, thanks, Ms. Watson.
I'm sorry. That's what happens when you're with someone with a brain injury, because you need to plan for this. Can I just say briefly, very quickly, that it's.
No, please. It's now, Ms. Watson. No, Dr. McLean. You've had. To be fair to Ms. Watson, you've had your. I've asked you how you propose the matter be progressed, and now I think it's my Ms. Watson's turn to respond to the same question. Ms. Watson, can I ask you how would the respondent propose that this matter be progressed?
The respondent's position is, as you've outlined, Senior Member, that Mr. Mclean is not an employee for the purposes of the SRC Act. There are directions in place that require me to file a statement of facts, issues and contentions and anything further supporting by today, which I have prepared and will file after this directions hearing is over. In those directions, the applicant's also been given until the 7th of March to put anything back to the tribunal that he feels the tribunal needs to see in order to support his application. After that happened, the respondent's position is that the matter should be listed for a hearing to determine the discrete point of whether the applicant's an employee or not.
Okay, so Ms. Watson, your position is to live by the current directions and see where they lead us.
Correct.
Okay, thank you. Did you hear that, Dr. McLean?
I heard bits of it.
Okay, so the respondent simply pointed to the fact that there are existing directions that require the respondent to lodge material today with the tribunal.
Today? Is that me?
You will have an opportunity. Sorry, no.
Oh,
to
them.
get onto your role, and then you will have an opportunity to respond to that material, and you'll have to do so if you wish to by 7 March.
Okay. Can you please find out how much money this is worth as well? Because as it stands, I'm a famous, infamous vagrant, and also Michaelia Cash has condoned that this AAT meeting go ahead, and she will not intervene, even though I've lost $1 million at the Australian Human Rights Centre, that Comcare is corrupt because Paul Fowler wouldn't help me with my... well, he rejected me, but he's the old head at WorkSafe, and WorkSafe wouldn't help me with my appeal. That's corruption. That's a police matter, but I'm banned from the police. What do you make of that?
Okay. Well, look, Ms. Watson, can I just ask you, is the applicant required to respond by 7 March, or is it an option to respond?
It's an optional response. Any member.
Thank you.
Well, can you please...
Sorry, go
Yeah,
ahead.
no. Well, it says here, under the NDIS Commission, a worker is anyone who is employed or otherwise engaged to provide NDIS supports and services to people with a disability. Workers can be paid or unpaid, and can be people who are self-employed, employees, contractors, consultants, or volunteers. Bam!
Okay, well, you think you've got a response then to the respondent's contention. That's something you can raise at the hearing, when you're responding material to...
I've already raised that before now.
Okay, well, look, you're giving an opportunity to respond to the material which will be lodged today by the respondent. You'll see that material, read it, and then you'll have an opportunity to respond.
Can I ask something else? Am I under investigation by the lawyer?
I have no idea.
Can you ask her?
I have no idea. Look, no, I'm not going to do that because...
Can I ask her personally? Am I under investigation?
Well, you can do many things, but Ms. Watson might be required to respond because I think we've addressed the way forward, Dr. McLean.
But I'm allowed to know if I'm under investigation, surely, as a secret thing, you know?
Well, if somebody's investigating you, maybe they're required to keep it secret. I don't know.
Well, can you ask her just simply? I just simply want to know.
No, it's not within the...
Why are you protecting her, sir?
I'm not protecting...
Why are you protecting her? And why are you condoning the Attorney General, who has already condoned that this meeting not go in my favour?
Dr. McLean, I'm not condoning or not...
Well, I have a letter from the Attorney General.
I don't condone anything. What I'm trying to do is perform the role which the tribunal is given under its legislation. Now,
I don't understand legislation. I'm just a dude.
Okay, well, I'm trying to explain what we're supposed to be doing. The tribunal's role under the legislation is to consider applications for review of certain decisions. And that's what our role is.
It is against human rights law to take advantage of a person with a brain disorder. It is against human rights law to take advantage of a person with a brain disorder. And can you please ask Miss Watson if she thinks this is an equitable and equal legal fight under legal principles, please?
It's not within the remit of her personal opinion as to what...
Well, she would know. She's had 20 years in the business as a Comcare lawyer. 20 years in the business as a Comcare lawyer. She's had 20 years in the business as a Comcare lawyer.
Dr. McLean, please, you know it's not relevant to our proceedings, her personal opinion. It doesn't advance the case one iota, her personal opinion.
You know what advances the case? Her having 20 years experience as a Comcare lawyer in the federal government, as opposed to me, who is just some dude who is trying his best with his marred brain by systemic abuse that the government has given me that has already killed me and then covered it up and put me into poverty, and WorkSafe is still doing it, and Miss Watson is an advocate of the government who has already killed me, and you are both taking advantage of a person with a disability. And in addition to that, I have already accessed the Attorney General and this particular issue of the AAT and this going ahead, and she condones my life to vagrancy.
And your point being, Dr. McLean, in terms of the progress of your application, you've made an application, I'm trying to get it progress, that's all.
I'm confused. I don't think it's fair to do this to me. I could lose $1 million, right?
Dr. McLean, you yourself said earlier in this conference that you don't want this matter not to progress. What I'm trying to do is work out how we progress it.
I'm confused, all right? I'm confused. I forget things. I forget what I say. I forget what I don't say. I said at the start, I don't want this to progress unless I have an advocate. And somehow you've twisted it around that it's gone ahead. And now it's going to the next point where I'm going to lose $1 million and the Attorney General is well aware of it and she already condones it. What is a mystery to you about this?
Dr. Mclean, as I say, you've made an application. I'm just trying to work out how to progress it.
I'm just trying to work out why you think it's fair and equitable that a person with a disability and memory problems can be opposed by a 20-year advocate and professional lawyer of the Comcare and government system against me, who is just one singular person who has already been killed by this government and then it covered up, and then I live in abject poverty. I bet you all had breakfast this morning, didn't you, to come to work? I didn't.
Well, I regret the fact that you didn't have breakfast, Dr. Mclean, but I'm just as a...
Why is that? It's because work cover has delayed, deferred and denied.
Look,
And it's unequitable, it's uneven, and it's not right.
Look, it's your application, though. You made it.
All right, you can't even tell me how much it's worth. Can someone at least give me a ballpark figure if I win? Is there a TPD payout, or is there a
It wouldn't be... Firstly, the tribunal's not in a position... It wouldn't be right of us to be advising a party when we're supposed to be the impartial observer.
You're not impartial because you said something before and then she just went along with it.
And secondly...
You ruled it.
And secondly, Ms. Watson...
I'm getting really confused and really upset and I don't really understand any of this. I'm sorry, I don't understand what's going on. All I understand is that you've made a statement and the other person, Watson or whatever, has just agreed with what you said. You're the top. You're the top. There's tops and bottoms, right? The bottom's the loser. The top's the person who makes the call. I come to a neutral place, like the Australian Human Rights Commission was, and they free kicked $1 million to the other team. And yeah, I'm sitting here with no fucking food. I'm sorry about swearing. I'm sorry. But you are at the top and you're going to free kick this work cover case to the other side. Now, if I'm not insured by NDIA or Comcare, can you at least advise me who that person is? Because it's been nearly a year!
Dr. Mclean, look, thank you. Look, you're in a tricky position and no...
Tricky?
Yep, in a tricky position, no doubt, but the claim you have made, I'm trying to get it progressed. It's your claim. What we're trying to do is progress, that's all. Now, I appreciate...
I just want some
another engagement.
Oh, yeah, here we go. Delayed, deferred, denied. All right, well, that's over, and I'll just go to the next thing. Send me the emails, and fucking we'll just go forward with it, all right? Yeah, no shit. They expected exactly what I fucking expected it to be. Thank you very much. I'm sorry for swearing.